Welcome to The Facts. I'm Rosalyn Tavanis. The Supreme Court of the United States is the highest federal court in the country and the head of the judicial branch of our government. Established on March 4, 1789, by the U.S. Constitution, the Supreme Court has ultimate jurisdiction over all laws within the U.S. and is responsible for evaluating the constitutionality of those laws. The Supreme Court includes 9 justices today, 5 of which are conservative and 4 which are more liberal. These justices have the power to check the actions of the other 2 branches of government, the executive branch of the president and the legislative branch of Congress. Recently, the Supreme Court heard a case involving gerrymandering. Gerrymandering is when certain districts of a state are drawn to either encourage or discourage Democratic or Republican candidates. These districts can be and are drawn, weaving through areas that make the district appear disjointed or in peculiar shapes. What this allows is the watering down of a district where a majority of either party exists and are dispersed among other districts so as to dismantle a majority. The case which was heard involves gerrymandered districts in Michigan. These districts were found unconstitutional by a federal court as they were gerrymandered to such a degree that it violated voters' First Amendment rights and the Constitution's Equal Protection Clause. First Amendment rights include freedom of speech or of the press. The Equal Protection Clause states, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States." The U.S. District Court of the Eastern District of Michigan ruled in April 2019 that 4 of the state's voting districts were specifically designed to disadvantage Democratic voters, deliberately diluting the power of their vote to ensure a Republican partisan outcome. The court's ruling ordered the state to redraw the voting district maps, calling partisan gerrymandering, quote, "a harmful practice that undermines our democracy," end quote. The matter was then heard by the Supreme Court. In a 5-4 vote, Chief Justice John Roberts reasoned that the question before the court, quote, "determining when a political gerrymandering has gone too far," end quote, could not be grounded in a, quote, "limited and precise rationale." This ruling was a blow to fairness to and protection of voter rights. Since the practice began in 1812, gerrymandering has been highly contested as it strikes against the equal and fair elections. Some 207 years later, the Supreme Court decided this issue, quote, "lacks judicially discoverable and manageable standards for resolving," end quote. This decision overrode the federal court decision to redraw the affected districts. One justice's dissent was written by Elena Kagan, a 9-year associate justice of the Supreme Court. She was nominated by President Obama in May 2010 and confirmed in August of the same year. She is the 4th woman to serve as a justice of the Supreme Court. Justice Kagan wrote a scathing dissent in which she called the majority's decision a low point for democracy. She further states, "I think it's important to underscore that fact. The majority disputes none of what I have said or will say about how gerrymanders undermine our democracy. Indeed, the majority concedes that gerrymandering is incompatible with the democratic principles." This brings up a question. Aren't the Supreme Court justices expected to decide the constitutionality of a law and leave partisan politics out of the equation in their decision? Thanks for watching. I'm Rosalyn Tavanis.